On the 6th of June, I interviewed Professor Greg Rose, a professor of law at the University of Wollongong, a senior fellow of the Hague Initiative for International Cooperation and a visiting fellow at the AIJAC, the Australian Israel Jewish Affairs Council. Professor Rose points out that the Organization for Islamic Cooperation's website states explicitly that the raison d'etre, the reason for the establishment of the International Criminal Court, was the cause of Palestine.
In relation to matters of its key interest, on the OIC website, it's explicitly stated that the raison d'etre for establishing the OIC was the cause of Palestine.
Professor Rose wrote a piece for The Australian. It was headlined, "Why the International Criminal Court's ingrained bias ensures no fair trials for Israel." It was published in The Australian on the 24th of May, 2024. In it, Professor Rose says the request for an arrest warrant against Benjamin Netanyahu and his defence minister, made by the International Criminal Court's chief prosecutor, is unsurprising, but not for the reasons many might think. And he points out an integral purpose of the International Criminal Court's political project has always been to delegitimize Israel. A target was drawn on Israel in the 1990s during the drafting of the Rome Statute for the International Criminal Court. The Rome Statute is the treaty which establishes the court. Professor Rose says the Organization for Islamic Cooperation made this a condition of the participation by Muslim countries. Now, with 57 members, the Organization for Islamic Cooperation is the world's biggest organization by membership other than the UN itself. Its participation was necessary for the global criminal law project to proceed. The OIC, the Organization for Islamic Cooperation, required that the International Criminal Court's definition of forced transfers of civilian populations be expanded as a war crime. He says new language introduced into the Rome Statute, again that's the treaty which establishes the International Criminal Court, criminalized the voluntary civilian migration of Jews into areas of Jerusalem, Judea and Samaria, which are now called the West Bank. Although the ICC statute, the Rome Statute, codified other existing war crimes, this became a new retrospective war crime invented in the Rome Statute. According to Professor Rose, this crime of allowing Jews to live voluntarily in the West Bank and Jerusalem has been under examination in the International Criminal Court since 2014. The previous chief prosecutor, in close liaison with Palestinian bodies and advisors from the Organization of Islamic Cooperation, geared the examination up to prosecutorial investigation level in 2020. The International Criminal Court is an effective tool to delegitimize Israel only if actively used by the staff of the International Criminal Court. This brings into focus the role and the politics of its chief prosecutors. Professor Rose says Karim Khan, the current chief prosecutor, had as his mentor and godfather Sir Mohammad Zafarullah Khan, who was Pakistan's first foreign minister and who always strongly opposed the Jewish state's establishment and existence, and that throughout all of his career, including his presidency of the United Nations General Assembly. They corresponded every week and stayed together when the elder Khan was in Britain. Khan describes the elder Khan's influence as pivotal. Professor Rose says the previous chief prosecutor, Fatou Bensouda, had been legal advisor and attorney general in her home country, Gabon. This was under the dictatorship of Yahya Jammeh, in which she oversaw the disappearances, the political prosecutions, and torture of opponents of the regime. Questionable dealings ran in the family, with her husband, a bulk oil dealer in North Africa, and her son, a drug trafficker in the United States. Professor Rose says, like dodgy police setting up false evidence for prosecution of a trafficker, fallen from their favour, the International Criminal Court prosecutors set up dubious charges against Israel. These are based largely on evidence assembled by anti-Israel non-government organisations who solicit Palestinian testimony, that is testimony from Hamas and Hezbollah, testimony that is partial and prejudicial. The prosecutors then put forward questionable interpretations of international law rules that only apply to Israel. For instance, a charge issued by Khan focused on alleging insufficient aid flows into Gaza, arguing that this amounts to a war crime of using starvation as a weapon of war. Imagine if that had been used in the Second World War against the Americans and British, and against the Americans in relation to Japan. Then he goes on to say the ICC prosecutor ignored several of the most salient facts, such as Hamas attacks on border crossings, thus interrupting flows of aid, and Hamas's seizure of aid convoys, Hamas's notorious stealing of aid, and its booby-trapping of homes, and its destruction of Gaza infrastructure, particularly water pipelines and electricity transmission lines. Khan, he says, contradicts the basic rules of international law of armed conflict, allowing attacks on combatants by treating Hamas combatants embedded in urban areas as civilian. He also invents a non-existent, perverse rule of international law, it doesn't exist, requiring the provision of humanitarian aid to the enemy in armed conflict. That didn't apply in the Second World War, that didn't apply in Korea. The networks of such prejudicial influence extend well beyond the International Criminal Court into other legal institutions. So Mohammed Zafarullah Khan was also at a time the president of the UN International Court of Justice, just like the president, the current president of the International Court of Justice, Nawaf Salam. Now, Judge Salam, he's the president of the International Court of Justice, he was also the Lebanese ambassador to the United Nations, where he was very well known for constant invective against Israel. Unsurprisingly, he hasn't withdrawn from the process of the International Court of Justice brought by South Africa, nor has he recused himself in the current cases against Israel before the International Court. Egyptian and Jordanian judges in the International Court of Justice are similarly quite ready to execute judgments against Israel despite their obvious bias from their previous high-level political roles. Although a principle of the rule of law is of the impartial judge, for which the disqualifying threshold is a reasonable apprehension of bias, this fundamental rule has no traction in the international justice system. The prosecutor, Khan, pretends Israel must be held to account equally with others. But the problem is not a failure to hold Israel to account. It is more fundamental. It's a fundamental failure to treat Israel equally under the law. Professor Rose says just as Jews were once excluded from polite society and subjected to double standards, today Israel is treated as the Jew of the nations, to be excluded from international society. He says the international legal system is politicized. It's a function of the United Nations, which in turn is a political institution dominated by non-democratic states. They drive forward their own narrow anti-Semitic interests with the cynical support of hypocrites. Of course, the International Criminal Court charges are no surprise. Incidentally, Greg Rose is a professor of law at the University of Wollongong, and as I said, a senior fellow of the Hague Initiative for International Cooperation and a visiting fellow of the Australian Israel Jewish Affairs Council. Now, having read his opinion in the Australian, I can only wonder that Australia actually joined the International Criminal Court. That was under the Howard government. And why on earth are we still in it? The United States isn't, by the way. Perhaps there is an answer to all this, and I'm very happy to read that and bring it to you. But I know of no answer to the charges, the very relevant charges by Professor Rose, that obviously the International Criminal Court, like the International Court of Justice, is a biased court and not really worthy of the name a court. If you're going to have courts with the participation of judges from undemocratic states, you're hardly going to get justice under the rule of the law.